Each side will have 15 minutes to present their arguments, and the appellants may reserve up to 5 minutes for rebuttal. So, gentlemen, have you made arrangements how you're going to do this?
Your Honor, we were told that our times would be split, and instead of 15 minutes, it would be 7 minutes. Is that correct?
Yes.
Oh.
Yes, your time is split, but I am going to give you an opportunity for rebuttal if you'd like. But you can't get 7.5 minutes each and then get rebuttal time too. As long as you two are happy, I'm happy.
We decided to split it.
That's
It's
fine.
not your
That's
honor.
fine.
Okay.
You may proceed then.
Good afternoon, Your Honors. Sean Boris on behalf of Appellant Amy Averett. I would ask that request 2 minutes for rebuttal.
So that means you only have 5.5 minutes.
5.5.
Okay, I just want to make sure.
I'll be brief. I may not need all that time. Well,
That's fine.
it's not very much time, but I still may not need very much time. As the court is aware, I've only made one assignment of error. It's a manifest weight.
Could you state your name, sir, please?
Oh, I'm sorry. It's Sean Boris on behalf of Appellant Amy Averett.
I messed him all up by asking so many questions to start with. Go ahead.
As I said, we would be requesting that the court vacate the trial court's order granting leave of custody to a relative and the trial court's adjudication that the child in this case was a dependent child. As I said, our assignment error is manifest weight of the evidence. We believe that the trial court did not take into consideration much of the testimony at both the adjudication phase and at the disposition phase, as well as at the emergency custody phase. There was testimony of several witnesses that testified that mother could take care of the child, that she had progressed in her case plan with previous children that have been removed, and the trial court should have taken that into consideration. And they were in error and could have used less restrictive means than granting legal custody to a relative. There could have been less restrictive means, protective supervision. There could have been temporary custody to mother. But if you review the record, we believe that there was a lot of testimony concerning mother's ability to meet the basic needs of the children, and that it did not, the court could have used other less restrictive means. In that the court considered much of mother's past history with children's services and with domestic relations court. Mother had 5 other previous children removed from the home. I believe in April of 2014. This child, in this case, was removed, I think, in December of 2014, and we would submit that there was much testimony that mother's current situation had changed in that 8 or 9 month period, and that the court should have considered that. And the child should not have been removed from her home, and that there wasn't a proper investigation to even determine whether or not the child was dependent. They just removed the child based on mother's historical involvement with the agency, not based on her current situation. And so, again, we would be asking that the court vacate the trial court's decision that adjudicated the child dependent and granted leave of custody to the grandparents in this case.
Thank you.
Thank you.
Please support Robert Cabrera on behalf of Father Kurt Burgess, Eleanor gets better. Your Honor, likewise, I would probably like to reserve 2 minutes in terms of rebuttal time. I would concur with the mother's lawyer in regards to his argument as well. Your Honor, I'd like to just argue that, in brief, raise the germane issues. I raised several assignment of errors, but I'd like to state a few things that perhaps aren't as dominant inside the brief itself. That is challenging for the appellate lawyers. The docket, for example, in this matter was very, very difficult to follow. There were many entries that were not provided in the docket. And part of presenting the procedural posture to this case, the appellate lawyer has to rely on the docket, and it's quite difficult. And I'm presenting the facts as best as I've been able to discern those, and I have likewise done an investigation with the clerks downstairs. The matter before this court is a legal custody to maternal grandparents, but based upon an adjudication of neglect and dependency. This child was born on December 10, 2014. As best as I can determine, this child was removed from the mother several days thereafter, on the 18th. I'm sorry, the 17th, about 7 days thereafter. There was a shelter care hearing that was affirmed, and then the matter was sought for contested disposition hearing. There is little to discern the basis for the removal of that child, but I'm arguing to this court that it was done based upon mother's prior action with the agency. I don't believe that there was a determination at that time of harm to the child. The child was removed from the mother essentially because she had failed to tell the agency that she had a child. Father was not served because my client Kurt Burgess was not served because he was at best a putative father at that time. He thereafter was adjudicated the father of the child and then did in fact file a motion for legal custody. So our argument is essentially that the court abused their discretion in placing the child with the maternal grandparents when father was willing and able to provide the necessary care for the child. And I would also argue, Your Honor, that the situation before this court is I represent father, and I am arguing to the court that his actions need to be addressed, not mother's. I think the record will indicate that the majority of the efforts by the agency involved the mother. The reason for the removal of this child involved the mother. Father was sort of a collateral source to the case, albeit he's a party and he's held to a burden as well. And I would also probably like to mention to this court that even though it's legal custody, it's a serious matter. With the exception of residual effects pursuant to Juvenile 4, the parent's ability to properly parent this child has been impacted. Moreover, it would require a substantial change in circumstances between the legal grandparent and the child in order for Burgess to come forward and to change it in the future. And I think the case law is very specific that when the order is made to legal custody to a relative, that it is a permanent order, that is intended to be permanent at least until the child reaches the age of 18. So albeit not a permanent custody hearing before this court, it's still a very serious matter. My client presented evidence to demonstrate that he was in a position to properly care for this child. The agency, on the other hand, and has the power of the state with all its resources, makes the decision or determination in terms of how they are going to proceed. They elected to proceed on a dependency and a neglect basis, and therefore they had a burden to meet. I would argue to this court that they failed to meet that burden. And by doing so, the court abused its discretion by not placing the child with the father, who has a natural right, a presumptive right, to raise his child as he sees fit. And that's, with that, I would address subject to rebuttal.
You may proceed.
Thank you. May it please the court, my name is Emily Kirsch and I represent Lorain County Children's Services. The assignments of error that were raised by mother and father were substantially similar, so I'm going to address them together and differentiate between the parties as I go through them. The first concern that was raised by both parents was that there was not sufficient evidence to prove that the child was dependent. Children's Services alleged and proved that the child was dependent under 2151-04C, B, and D. I'm going to focus first on D because a lot of the facts that show that the child was dependent under D were also used to prove that the child was dependent under the other subsections. So under subsection D, it really focuses on the historical concerns of a parent. It's a two-pronged test. Under the first prong, it must be proven that the child is residing in a household where a parent committed an act that was the basis of an adjudication of another sibling. In this case, the testimony was clear that mother had 5 other siblings, and Kirk Burgess was the father of 3 of those siblings. On September 24th, 2013, 4 of those children were adjudicated neglected and dependent, and the youngest one was adjudicated abused, neglected, and dependent. The next prong that must be proven under the dependency statute is that because of the circumstances surrounding the adjudication of the other children, as well as other conditions in the household, the child in this case is at risk of being abused or neglected. As to mother, there were 4 concerns that led to the adjudication of the other children. The first concern was mother's drug and alcohol concerns. When KB, the youngest child before the child in this case was born, mother and KB both tested positive for cocaine at birth. After that, there were 2 other incidents of chemical dependency that showed an indication of crisis. In January 2014, mother had overdosed by taking rum and an undetermined amount of pills. During that time, mother still had custody of the children. Additionally, after that, mother tested positive for an opiate, but she was unable to produce a prescription for that. This child, KA, was in danger of being abused or neglected because mother never addressed those drug and alcohol concerns. Mother never engaged in intensive outpatient treatment that was recommended. Additionally, the testimony established that there was no internalization or realization that the drug and alcohols were a concern. As a result, KA was in danger of being abused or neglected. The other concern was the basic needs of the children. The circumstances surrounding the adjudication of the other children were that they were living in a poor home condition. During the time that the agency was involved, mother was not allowing Children's Services access to the home, to view the home, to ensure that the children in the home would be safe. However, in January 2014, service providers were able to gain access to the home, and they described it as deplorable. As a result, those children were removed from mother's care at that time. This child would be at danger of being abused or neglected due to mother's inability to keep the home in a sanitary condition. The testimony established that she was never able to keep the home in a sanitary condition while she had custody of the children. Additionally, the testimony established that mother failed to recognize that the conditions of the home were a problem. As the guardian ad litem had testified, I have no inclination that she can sustain it if she doesn't know what caused it in the first place. The other concern was that when the caseworker went to the home on December 17th, the day after the removal, she observed household items and garbage piling up outside the garage. The caseworker had attempted to go to the home after learning that mother had had KA. However, mother was not allowing access of the agency to the home. She had made the caseworker stand on the porch for 10 minutes until she called her attorney. Finally, mother let the caseworker in but would not give the caseworker any information about the child, a name, a date of birth, and was completely uncooperative. Even more concerning is that father was home and present during this incident. He was upstairs and he did not make himself available to the caseworker. When it was subsequently questioned why he did not make himself available to the caseworker, he indicated that it was mother's business and not his in regards to the child. Those circumstances leave this child being at risk of being abused or neglected.
Did he say with respect to the child or with respect to the condition of the house?
Your Honor, I believe it was with respect to the child.
And do we know whether father was living there?
As I will get to in a minute, Your Honor, there was testimony that he was renting a room out of a house. However, the testimony also established that there was concerns that father was living in the home. He testified that he spent a great deal of time there, and the concern from the guardian ad litem and the caseworker was that father was living at the home, and if not, he was spending a substantial amount of time at the home.
Other than that single contact with the father on the date that you just referenced, it seems to me from reading the briefs that there was nothing that the agency did with respect to him in terms of attempting to investigate whether the children could be cared for by father.
Your Honor, to answer that question, the record in this case includes the court took judicial notice of the previous dispositional orders with those 5 children, because it had been a 3-day contested hearing in the middle of this litigation. In that case, the testimony was very clear that father was a passive participant. He was not active. He had never indicated that he wanted anything to do, not anything to do. He never indicated he wanted custody of the children. For example, the guardian ad litem had actually testified as to why he never went to father's house. Was he asked father, would you like me to see your house to see if it would be an appropriate place to care for the child? And father indicated to him that it was not necessary because if he had the child, he would be at mother's home. So there were attempts made to...
I'm getting a little confused. That was in the other cases?
Yes, Your Honor. And in this case, the mother requested that the court take judicial notice of all that testimony.
But he filed for legal custody in this case?
In this case, he did, Your Honor. That is true. But the concern was that he was passive and had never, the agency had been involved with father for 1.5 years. And during that time, he never took an active role in wanting to care for the child. The concern, I think
This
that...
child?
The other child, and this child. I know, I'm sorry, Your Honor.
Sorry.
And this child as well.
But he had filed for legal custody in the other case?
He did, Your Honor. He did, but he had never communicated with the caseworker or the guardian ad litem that he wanted the child to be in his home.
Well, I guess the question is, after he filed for legal custody, the agency is put on notice that now he's stepping up for whatever reason. And my question is, what are we going to find in the record independently of mother and the issues that she had, that the agency, considered father and evaluated him according to the factors that they should have used?
Your Honor, the agency, after father did file a motion for legal custody, they went to the home where father indicated that he was living. The caseworker testified that when she went to the home, a woman that she did not know answered the door. And the woman indicated that father did not live at that home. Later in the day, an individual called the caseworker and said that the person that had answered that house door was incorrect and father did live at that home. I believe it might have been a little too close to the contested hearing date, so the caseworker did not go back out to the home. But there were concerns about whether or not he was really living at that home. The individual from whom he was renting the home came to the one hearing and testified. And she testified, her testimony conflicted with father's testimony. For example, she testified that father was on a written lease at that home. Father himself testified that there was no written lease. Additionally, the time frame that father testified that he was living at that home was very different than the time frame that she indicated she was living at that home. He was living at that home. The other concern about this individual that he was renting the home from is this was the individual that mother had supposedly entered into a surrogacy agreement with. The testimony established that when mother became pregnant with this most recent child, she told some people, specifically Children's Services, that she was acting as a surrogate and that she was carrying this child for this other woman that could not have children. However, she was also telling service providers and other individuals that she was planning on keeping the child. It appeared to the court, as well as to Children's Services and the GAL, that mother was attempting to do some kind of surrogacy agreement to avoid Children's Services involvement. I believe that the magistrate described it as a preposterous notion that she would do some kind of agreement to avoid Children's Services involvement. So the agency did do diligent efforts to determine whether or not father would be an appropriate caregiver. Additionally, Children's Services proved that the child was dependent due to concerns about mother's mental health and her parenting concerns. The testimony established that the children had lacked supervision while they were in mother's care. Mother had difficulty managing the stress of parenting, and she was not putting the needs of her children above her own. Furthermore, the testimony was that she was unstable, hostile, and aggressive. This child is in danger of being abused or neglected because mother never demonstrated any changes with her mental health. She did some services, however, she never internalized those concerns. Furthermore, mother was exhibiting the exact same behaviors that the agency had when they initially became involved. One example of this of mother not putting the child first was shown with the breastfeeding example. Mother was breastfeeding the child, and anytime the child needed to be breastfed while the child was with maternal grandparents, they would call her and she would have to go to the house to breastfeed the child. There were times when it would take her 10 to 15 minutes, and in one case an hour. The maternal grandparents asked parents if they could, ask mother if they could give the child formula, or if they could have a bag of breast milk to feed the child, and mother would refuse, and anytime it was brought up, the testimony was that mother would go off, and at one point she even called the maternal grandmother a psycho for asking for food for the child. Because of this, mother had failed to demonstrate that she made any of the behavioral changes, and the circumstances surrounding the adjudication of the other children were present for this child. As to father, the concerns were mainly that father was a passive participant with KA. We've sort of touched on this, so I'm going to skip over that for a little bit. As well, there was also concerns about father's ability to meet the basic needs of the child. And again, father had been homeless for a majority of the time in the case, and then recently had indicated that he was renting a room, but as indicated earlier, there were concerns about that. Therefore, Children's Services proved that the child was dependent under 215104D. Children's Services also proved that the child was dependent under 04C, which is that the child lacks adequate parental care because of the mental health of mother. And under subsection C, Children's Services proved that the child was dependent because the child was one whose condition or environment was such as to warrant the state in the interest of the child in assuming guardianship. Children's Services also proved that it was in the best interest of the child to be placed in the legal custody of the maternal grandparents. Mother's attorney indicated that legal custody was too restrictive. However, this is a case that the agency had worked with mother for over a year and a half. The agency had attempted to do protective supervision in the past, had attempted to do temporary custody in the past, but mother did not make any case plan changes. Additionally, when Children's Services had protective supervision, mother was not cooperative with the agency. She wouldn't allow the caseworker access to the home. She wouldn't sign releases. She was not cooperative. Therefore, protective supervision would have been futile. Children's Services proved that the child should be placed in the legal custody of maternal grandmother by relying on the factors of 2151.414D. The testimony established that mother did not have the best interactions and interrelations with the child, as she did not put the child first. Additionally, the testimony established that mother had temper flares in front of the child. As to father, there were concerns about that all his interactions would be with mother. As the guardian ad litem testified, and I quote, "I don't believe if he were the custodian that he would be the primary caregiver." This was further compounded by the fact that father never took any steps to meet with the GAL to assess whether or not his home was appropriate. Under the second factor, the court looks at the wishes of the child as expressed through the guardian ad litem. In this case, the guardian ad litem was recommending legal custody to the maternal grandparents. The court also looks at the custodial history of the child, as this was a child that was under 3 months of age. The custodial history was obviously not very long. However, the child had been in the care of the maternal grandparents since 6 days after his birth. The last factor looks at the child's need for permanency and whether either parent can provide that permanency. This also weighed in favor of granting legal custody. As indicated earlier, the Children's Services worked with mother for over a year and a half, and she did not make case plan progress. Children's Services also worked with father for over a year and a half, and he likewise did not make case plan progress. Furthermore, the caseworker and the guardian ad litem indicated that based on all their work on this case, they did not know what other services could be in place to show that the parents could care for the child. Based on this, the trial court did not err in granting legal custody to the maternal grandmother.
Thank you.
Mother's historical involvement with Children's Services certainly is relevant, but it shouldn't be the sole deciding factor of whether or not this child was dependent and should have been removed from the home, or any future children should be removed from the home. There was testimony at the adjudication phase from the ongoing social worker, Ms. Furman, that mother could meet the basic needs of the child, that mother's home was appropriate. There was no indication that mother was not addressing the child's medical needs. Mother was currently engaged in mental health counseling, and there was no reports of any drug abuse. That prior children, one of the children had tested positively for cocaine at birth. This child, there was no positive drug screen for any drugs at that time. would submit that this was really just a rubber stamp for this child, that mother had 5 previous children removed from her home, and sometime later had this child, and Children's Services just removed her from this child from mother's home based on her historical involvement, and didn't take into account mother's current situation, and wasn't really willing at that point to work with her on a court-ordered case plan. There was testimony from the maternal grandparents that they thought mother could take care of this child, and was taking care of this child. The child was removed within a week from the time the child was born, taken to maternal grandparents' home. Mother was staying with maternal grandparents and caring for the child, was staying overnight, was breastfeeding the child. So, again, much evidence was not taken into account and given adequate weight for this child. Thank you.
Thank you.
Well, of course, Your Honor, Father Burgess would take issue with the agency's position that they did diligent efforts in regards to father. The agency's efforts in regards to the mother was never equal to the agency's efforts regarding to the father. And it's always that case. The mother is always the primary individual that the agency works with. Fathers are always collateral. And then they use that, or attempt to use that against them. So he files a motion for legal custody. And they indicate, well, he's a passive participation. Well, maybe he's a passive participation because that's how the agency viewed him, and that's how the agency dealt with him throughout the entire process. It's not uncommon for an individual all of a sudden to wake up and say, wait a minute, this is one child, not 3 children. I have a job now, I have a place to live. I'm going to stand up and take responsibility for my child. But then finds out that he's frustrated in that effort because he was never taken seriously in the first place. The idea that they showed that he had a girlfriend, and apparently they were a little bit untruthful when someone comes to the door knocking at the door. I hope they don't hold that against the rest of the world, because sometimes we do that. When someone calls and we might say, no, he's not home, or Attorney Cabrera is not present, et cetera, et cetera, et cetera. Now, I understand, I don't mean to be minimize the situation. But on the other hand, this is becoming very serious here. The agency has a tremendous amount of power. Well, with that power comes a tremendous obligation to do the job and do the job right. When you read this thing, judicial notice, because you were a bad parent 2 years ago, or a year and a half ago, you're a bad parent today, what are you saying about restorative measures? That everything that you've done with this mother is worthless?
But that's part of the legislature has determined that that is something that the trial court must take into consideration.
And Your Honor, the situation, we're not the trial counsel, and quite often we have to try and backdoor different things. Extremely difficult. Plus, I've given up. It doesn't work. But the truth of the matter is, even in this particular case, recommendation from the JAL, I did raise an assignment of error. This JAL did not do a competent job. At best, it was inadequate, but did not do a competent job. And to come forward and say, well, you know, they didn't cooperate, they didn't call me, so I didn't go out there and talk to them. His charge is the child, to present to the court exactly the reasons behind his recommendation. I am extremely aggressive as a guardian ad litem. He should have as well. If you're making a recommendation, then you ought to be able to back it up. And I don't see it here based on this. It is true there was involvement with the agency, father was passive or what have you. But at some point he filed a motion and he took charge and he expected to be treated that way, and he was not. And I don't believe the evidence reached the level on this particular child in this particular circumstance based on the evidence that was presented at the hearing. And I'd ask this court to reverse this.
Thank you both, for both sides, I should say, for your presentation to the court. The court will issue a written opinion on this matter as well as release it on the website. Thank you so much, and court will be adjourned until Thursday.